those that are attending physically here at Afya na Haki Institute, and the membership that is attending virtually. We thank you so much for all these treasuring sessions organized by Health and Law Cluster. We are ready to commence. I think we'll take you through briefly what the Health and Law Cluster is, why we think this theme is very important for us to know. One, allow me to note that the Health and Law Cluster is one of the vibrant clusters of Uganda Law Society. It has been there for coming to 5 years now, since inception in 2017. It has laid ground for conversations, discussions, and it's a think tank on health and law aspects. So we treasure the contribution of the cluster, and we extend our thanks to the Secretariat, which does whatever it takes to have the cluster run its initiatives. And we also extend our gratitude to the Center for Health, Human Rights and Development for hosting the cluster and working together with Afya na Haki Institute to ensure that things move in the right direction. Today, we have a conversation on a dear subject matter, which is implications of the Public Health Amendment Act. When we speak public health, some lawyers believe that that's a matter of the medical personnel, medical professionals, but increasingly we see that it is a matter for everyone. And as lawyers, we have a huge contribution to make when it comes to public health issues. I don't want to preempt the conversations, but at the end of the day, we'll hear and appreciate that this is a subject that is critical for the legal fraternity. So we are discussing a law which was amended, an 87-year-old law which was amended. It has very interesting provisions, very interesting subjects that we are going to be discussing. We have on board quite resourceful and experts in the field of public health and the law, and they're going to be sharing with us the different topics that will intrigue and initiate a conversation on the issues. And there are quite a number of opportunities for us as lawyers in this conversation. There are quite a number of opportunities we'll pick for those interested in health and law practice. They are very interesting opportunities. And those that are interested in the academia, there are also very important points to pick that can contribute to a board of knowledge in the subject. Allow me to take you through briefly our agenda for today. I'll be your moderator. I'm Seriko Ibrahim. I coordinate the cluster, and we'll start with opening remarks from the CEO of Uganda Law Society, and after the remarks, we'll go into a keynote address by Dr. Mulumba, who is the first chairperson of the cluster of health and the law. He will be taking us through the legal implications of the Public Health Amendment Act that is law now. It is law. We will again then have an overview of the Public Health Amendment Act by Ms. Martha Achani Isabella. She works with the Ministry of Health. She's a legal practitioner. She was at the center of drafting this Public Health Amendment Act. So we deemed it fit that since she was at the center, she'd be best placed to take us through what this law means, and then that can trigger further conversations in the different topics. We deemed it necessary to have pharmacists for our conversation. We'll have Dr. Chibira Dennis to point out some of the ethical issues when it comes to public health measures that are within the law, and share insights on lessons we learned from COVID-19 when these measures were being implemented. So he'll be digging deeply into the ethical considerations. Again, when we look at the Public Health Act, the number of intellectual property issues that emerge. You talk about public health, you talk about drugs, you talk about vaccines, you talk about intellectual property rights. So we'll have, again, an insight from Dr. Paul Ogendi, who is a lecturer at the University of Nairobi, but also is a legal practitioner in Kenya. You'll also appreciate that during COVID, we had a lot of solicitation from the public in terms of funds support the COVID measures, and that directly links to the public private partnerships. So we'll have a thorough conversation. What does it mean? Does it have any legal legitimacy? If government calls upon the public to make contributions to a public health cause, is it grounded within the law? What are the implications? What are the implications of the public partnerships health policy? So we'll be, again, deeply going into that subject. We cannot talk about public health and talk about rights. So we'll have a lawyer who works with a civil society organization that deals with rights issues, that promotes the right to health in Uganda. So Ms. Nachibu Kanunu Musisi will be tackling the human rights implications of the law and what we need to consider. We believe that after all those sessions, we'll have a plenary where will be those that have questions will be posing questions, but in the course of the conversation, you can always send your questions or comments in the chat. They can then be responded to by our facilitators for today. We'll have closing remarks from Dorothy Amnon. She's also a member of the Uganda Law Society. So that is our agenda. I'll directly go into the remarks, the opening remarks by the CEO of the Uganda Law Society. Thank you.
Okay, thank you very much, colleagues. Good morning, everyone. Our panelists, the membership online. You're welcome to the CLE on the health, with the focus on the legal implications of the Public Health Amendment Act. Health and the law are now inseparable, and I'm glad that the cluster has put emphasis on areas related to health and the law. I would like to begin by thanking the cluster for this engagement, as well as our partners, Haki, Yana Haki, Ahaki. My apologies, Mr. Mulumba and Sereko and Dorothy and the team for mispronouncing Ahaki, Afiana Haki. It's a Swahili word, so please forgive me. As well as Sehad, for accepting to partner with us during this session. I also want to thank the special facilitators, Mr. Mulumba, Achan Martha, Isabella, Dennis, Chibira, Dr. Paul Ogendi, Dr. Ahimbi Siwe, Dr. Nachibu Kanunu, Dorothy, as well as Mr. Serikali moderator. I bring greetings from the Executive Council. The President is currently opening a workshop by ELS on civil society freedom, so he's not able to join us, but I bring greetings from the President and the Executive Council, as well as the rest of the Secretariat. I hope to be part of these discussions, and I believe with the panel that has been assembled, we shall have a very enriching and fruitful discussion. Thank you very much, and thank you, the Secretariat, for organizing this, and I wish you all good deliberations. Thank you.
Thank you so much, CEO, for those interesting remarks. We are going to our next session, which is the keynote address. This keynote address is going to usher us into the subject matter of discussion today. So we'll have Dr. Mulumba Moses. Dr. Mulumba Moses is one of the experts we know in the world when it comes to global health, when it comes to intellectual property, especially access to medicines. He's the Director General of Afiana Haki Institute, which is hosting us today for this CLE. He's a founding executive director of the Center for Health, Human Rights and Development, which has done an formidable role in pushing for health and law realization in Uganda and East Africa. They have done a lot of litigations in the subject of health, and we have quite a number of precedents in the area of health and law. He's the first chairperson of the Health and Law Cluster and first convener of the cluster. He's an expert in human rights, global health, and access to medicines. He has litigated health and law related cases. He has researched, he has written publications. So I think he's the best expert to usher us into this conversation. Allow me to invite Dr. Mulumba Moses to make his keynote address. He has shared his apology, he will not share his video. His connection is not good. So bear with us, he'll be presenting without displaying his video. So Dr. Mulumba, kindly join me in welcoming him. Those that are attending virtually, you can clap virtually to welcome Dr. Mulumba to join us. Thank you. Dr. Mulumba, kindly take over.
Thank you so much, Mr. Ibrahim Nsereko. Kindly confirm that I can be heard.
We hear you very well, Doctor.
Great. Thanks a lot for this space and for continuing the good work of the Health and Law Cluster. I am a proud alumni and member of the Uganda Law Society Health and the Law Cluster. I think that the continuation of the relationship between health and the law is something that is very important. And I think there has been no better time to think about this particular relationship, especially for lawyers, than the time that COVID-19 actually demonstrated to us. The subject for today's conversation is capable of interpretation in various ways. And I think that I have been given the tough job of giving context that will give a grounding for all the other speakers and the very important topics that they are going to cover. Unlike the usual keynote addresses, if I went into the depth of the entire subject, I think the risk would be that I almost speak about the things that everyone is going to be talking about. But let's think about this concept of public health law and the entire concept of the lawyer and the role of the lawyers as part of public health. I think it's something that has emerged, and it is something that we need to think about very deeply as practitioners, and not just think about, but also clearly think about how practice would look like amidst the public health emergencies that we've been facing. I think there have been several things that have been raised over the scope of legal practice and public health. And some of the questions for the lawyers have been, do we have practice or do we have relevance when we have situations like the pandemic that we went through? And there is no question about it, because the close to 15 years that I've been working on health and law, it's been very clear that lawyers remain to play the usual traditional central roles that we usually do. But at the same time, I think we also become very technical as part of public health. And if there are no legal inputs of lawyers as part of public health, there are a number of things that are missed. First, we continue to play the advisory role across the board. So lawyers are in government agencies. They are continuing to engage with communities, but they also deal with groups, individuals, and companies, and advise them on things that they have to be doing as part of the national responses of public health. So that advisory role certainly is something that is very important. and lawyers continue to play. There is a whole practice around legal advocacy and representation. We've seen that amidst COVID-19, there's been a lot of legal representation of individuals for several things. Some are very directly related to public health itself, but some are because of the emerging things that pandemics throw into the global world. I think we've not had bankruptcy more than we've had during the pandemics. So therefore, lawyers being more innovative in even dealing with commercial issues as far as we've not thought about as part of public health becomes something important. But how do you deal with that? What are the legal things that emerge in situations that you've not thought about before? And they bring things like, bankruptcy. The whole practice of banking, I think, changed in a way where rules that have not been thought about, or where the principles that concern with natural acts like public pandemics, like the one we faced. What do all these mean for lawyers? And how do we move away from the traditional legal practice that we are used to of facing our clients to situations where we are not actually able to face the clients and we are doing work virtually, amongst lawyers, virtually between lawyers and clients, but also virtually in terms of court systems. I think we saw that public health and pandemics were pushing us more than we have thought about to actually have proceedings, filing of court documents, and everything done virtually. And these were pushing us from the traditional practice that we've thought about. So in sort of answering the question of public health and legal practice and the lawyer, I think there are different dimensions that we need to think about, and we can't run away from them. We can't close practice. Practice has to go on. It's been interesting that if you read statistics around other countries, I think lawyers have made much more money in the pandemic and post the pandemic more than before. So many stories are told about how legal inputs became much more important than we had thought about. So the whole thought around legal practice amidst public health crisis is one aspect that one would want to interest themselves and think about. Away from that, when I come back to the public health legislations themselves, I don't think that this is the first time that public health law was becoming important. I think even before colonization, long ago, we saw that public health interventions in form of laws have been used over the centuries in the past. You may know that in the early days of European colonization, of even North America itself, the quarantine statutes were reported way back in the mid-17th century as part of legal interventions that are important for controlling situations of public health. Yellow fever, I think, has been a big thing. Those of you that do travels, you know that up to today, without the yellow fever certificate, you can't move if you're from countries like Uganda, where we come. These are not just public health pronouncements. These are pronouncements that are a result of law that is made not just at domestic level, but that is made at the global level, where we have rules, and my colleagues will be speaking about these global rules that mandate that at the national level, there must be requirements that people are vaccinated, and therefore they have the travel certificates that are grounded in public health. So right from the 70s, yellow fever vaccinations have actually been happening. It's just that lately, it's been an African thing, mostly African and low and middle income countries, where now the developed world seems to be using part of the rules to sort of control the movement of disease. As to whether that has been achieved, I think remains a big issue. But the whole idea of the law as a primary tool for prevention has actually been evolving for very many years. And it's not just now that we see it. In the 80s, things changed a bit from very controlling means and legal principles around public health to actually situations like HIV/AIDS and how we deal with HIV/AIDS and the sort of legal questions that come with situations of HIV/AIDS. And we saw a lot of panic and legislation that now introduced more criminal sanctions around behavior, criminal sanctions around actions that people take. We are still yet to accept some of these situations, but that's where we actually are. So developing of legislation began to evolve beyond just common law principles that we are used to actual interventions on particular diseases, building on not just the past 17th century principles that I've talked about, but thinking about much more infection control in the 80s than before. I think lately, in the 2000s, the public health legislation has moved much more into non-communicable diseases and the controlling of non-communicable diseases, much more than we've thought about. And the clear examples are around tobacco control legislations that we are seeing becoming important, both proactively by governments enacting these controls around non-communicable diseases, but also private sector pushing back on these controls of government. All these are areas where lawyers play a role. You'll have lawyers on the government side. You'll also have lawyers on private practitioners or private companies that eventually push back on these controls that are happening. The thing is that it is clear that the issue of powers, duties, and restraint on behalf of government becomes very, very important. But I want us to note, if we forget everything else, that when we talk about public health law, we need to make a distinction between legislation that is targeting public health and legislation that is about healthcare. I think every time we talk about law and health, we sometimes tend to confuse both. And today's subject, I think, is not about healthcare legislation. In one way or another, healthcare may be part of the issues that are part of public health, but it does not necessarily mean the same. I think for the years that we've done work, we have overly focused on the law and healthcare and the law and medicine for a long time. And this field is very important, but a little bit different from public health. And these are the key distinctions that we need to know. I think when we talk about healthcare law or law and medicine, we have to be focused on the field that revolves around several broad themes of healthcare systems. Part of this is around delivery. How do we deliver healthcare? What are the systems that do that? What are the regulatory functions that support delivery of healthcare? And in this, if you're in the context of Uganda, if you're a lawyer that is working with part of the regulatory functions of the National Drug Authority or National Medical Stores, or Mulago Hospital, or any other facilities, part of the laws that you'll be focused on are how those systems deliver care and how we deal with care in those perspectives. Again, I need to say that this doesn't mean that this particular subject does not become important for public health. But it's important that we draw a distinction, that when it comes to this, we are actually dealing with law and healthcare. There are things around financing which are important lately. How do we ensure that there is justice in financing? How do we ensure that we remind governments obligations on financing healthcare? And then there are also issues around research and innovation. Of course, these are usual things on law and legislation and not necessarily public health, but they become important. So things like competition, dealing with competition and intellectual property become important. But if I considered those without necessarily looking at pandemics, I think the whole focus will be on healthcare and the law. On the other hand, when we begin talking about public health, we are talking about legislation. We are talking about interventions that ensure conditions for people to be healthy. And this is very important. Before we talk about how care is delivered, we focus on public health, on conditions. And there are several things, several examples that one can think about, and how this becomes important and different with healthcare law that we usually see. First, the health and safety of populations is a focus rather than the health of the individual, which is different from healthcare law. Healthcare law always focuses on the individual. Now, public health focuses on population and the health of the population and how you deal with the health of the population. So any interventions around health of the population, in most cases, relate back to public health. Second, prevention of injury and disease rather than actual treatment and care. So when it comes to public health, there is a tendency to look at how the law is used to prevent injury and disease rather than treatment and care itself. Of course, treatment and care becomes important at a certain point, but that's looked at within the framework of healthcare. The third point is around the relationship between government and community, rather than a relationship between physician and the patient. And this is still very important. In usual healthcare legislation and practice, we tend to look at the doctors versus the patient and that relationship. How have they respected consent? How have they respected the rights of the patients beyond consent to several other aspects? In public health, on the other hand, it's government versus communities. What sort of interventions is government doing to support the communities, and how are the communities responding to these interventions? And then the last distinction or principle of public health is around more population-based services grounded in scientific methodologies of public health rather than personal medical services. So how do we focus on population-based services, and therefore things like biostatistics and epidemiology becoming much important versus the receipt of personal services and the delivery of the same. Now, these are very important for legal practitioners to determine what exactly are we talking about. Is it healthcare or is it public health? If it is public health, it is more the public, which is government versus community. And that's very important to know. And that comes with questions of power. It comes with questions of mandate. It comes with questions of obligations in a way that feeds into communities much more. In terms of the law, you realize that in the end, there are two critical overlapping ideas that are very important. First is the public health law itself, which is the body of statute legislation that provides the foundation for so many public health agencies. So the law itself becomes a very important focus. And then the second point that overlaps sometimes beyond the law, it is law and public health. And within this, we look at the regulations intending to improve morbidity and mortality rates across the population. So it's not just about foundations for public agencies to operate, but it's also about how we use these laws to prevent morbidity. And in the case of COVID-19, that was important. Now, there are many things to think about as we navigate these, but I think three critical, difficult things are important for lawyers to know and think about. First is the fact that the laws on public health have been very old, and they have been modeled around very old, archaic situations. So you'll find that we are dealing with laws that are 100 years plus. In the context of Uganda, as Ibrahim indicated, we are dealing with an 87-year-old legislation. So it becomes sometimes difficult to ground new understanding of science and new contemporary issues and legal norms, including things like individual rights, on very old legislations. The second is that there is always a fear of disbanding the old laws. So in a way, we create multiple layers across the laws. We don't throw away the old, but we create the new, that also we want to work with the old. And this becomes a huge problem sometimes. And we saw it in COVID-19, where every single day, the rules will be changing around how to deal with COVID-19, but we wouldn't throw away the old rules. We would be building on the old ones to do the new ones. And the president ended up appearing on TV almost every after a week or every after a month, with some time to come back with new rules that the ministry had come up with. So you end up dealing with multiple layers of laws to be addressing the same subject. And this makes it difficult. So for lawyers, it becomes things from employment through to how vehicles move, through to communication and flow of information, and so many other things that are not necessarily within the same practice. So it would be requiring a lawyer to have an understanding that it's not just public health, it's also about ICT, it's also about governance, it's also about human rights and politics, and several things that we are not traditionally used to. So the multiple layers of the law that is used in public health is very important. So you end up being a practitioner that is not just grounded in one space, but you must be grounded in several states, several spaces. And then the third point for lawyers to think about is sometimes the inconsistency of these laws within the states, but also across the territories of the states. So you will have international guidance, but at the end of the day, states have the authority to determine how they want things to be done individually in their countries. So you can't be an expert of public health law just in your own jurisdiction without understanding what's happening in other jurisdictions. If you are traveling around COVID-19, you would see how the selective application of rules works across the world. And it impacts races, it impacts communities, it impacts where you're coming from. And it becomes a problem. So what was illegal in one state was legal in the other. And it sort of became a problem several. So as practitioners, when you think about public health law, that's something that you need to think about. The sort of 5 models that I think everyone will be talking about in one way or another within public health, very broadly, that we need to think about, include the question of power of the state, the power to tax, the power to spend. I think in COVID-19, this was very, very important. We saw that public health became a trade issue. It became a very big business, but at the same time, it required government to spend in one way or another. So there are rules around how do we procure in emergencies, public health emergencies. So just lawyers specializing in procurement and public procurement in emergencies became very important and becomes very important. What do we tax? What don't we tax? As we're bringing in commodities to deal with public health emergencies, what are the tax rules that actually apply? So really, the first model is understanding the sort of things that happen in public health versus situations when we don't have public health emergencies. The second model is around power on information environments. A lot of information comes through in public health emergencies, a lot. And therefore, public health legislation that we are talking about, if it fails to address how we deal with information environments, it's a missed opportunity, huge missed opportunity. There is a lot of misinformation. There's a lot of selling of commodities on false information and false trading. There are many information campaigns on issues that happen, and these may be anti-competitive, they may be disinformation, but we also have religious beliefs and people sharing their religious beliefs as part of critical information. How do we regulate all that in states which are secular like ours, but very religious based, and we are dealing with it? So information environment is very important. The third is around regulating the individual, because the individual is a vehicle for the transmission of diseases, but also the individual can also be very important in terms of making sure that the control of diseases happens when they are part of businesses, when they are part of healthcare delivery. So how do we control individuals? And we struggled a lot with this in public health in COVID-19. How do we ensure that individuals move? How do we select individuals and say, these are essential individuals? These are essential professions that we need to, essential businesses that we want to think about. And the individuals are at the center of this. So there is a need to strike balances, because individuals come with, these days, a cohort of rights, lots of rights-based approaches become important, but also civil liberties of the individuals. If the individual is sick, what sort of rules do you use on sick individuals? In COVID-19, if you went to collect your results in Mulago in the first weeks and you're positive, you would already find the army lined up for the individuals to get you. And, do you arrest them? Do you incarcerate them? How do you deal with the authorities and regulate people? It's been the individuals who are immunized. If individuals resist the immunization, how do you deal with the individual? Do you stage somewhere and use security officers to force them to be immunized? These are all things we've seen during a public health emergency. And therefore, as lawyers, how do we, as lawyers for these individuals, how do we deal and navigate those complex issues that we never think about? The fourth is around, the regulation of many things, including businesses, that comes with a lot of interests. If it's public health, for instance, you want to control cigarettes, how do you use the law to do that? If it's a public health crisis on firearms, how do you deal with that? I think the US is facing that for a long time. How do we regulate things traditionally we've not been regulating before? If it's HIV/AIDS, how do we deal with sexual behavior and delivery of care? So there are many things that emerge. What are sort of public health litigations or regulations that would emerge that one would want to think about? The whole idea of indirect regulation becomes important as a fourth factor. And then the last one that is important is deregulation. There are things that we've traditionally regulated, that we've traditionally made offenses around. Do we de-offense them? Do we deregulate them when we have public health situations? How do we deal with that? At what point in time do we apply harm reduction models such that you say, no, it's a public health emergency, but at the same time, people are using drugs and they're using syringes. Do we still have to use the criminal laws to deal with these things, or do we need to deregulate them? So those are critical pieces that I think my colleagues will be building on as they deal with the issues. The very last thing that I want to talk about is the model that we've been having as a country. I think the Ugandan legislation on public health. I think we are very much dealing with a question of colonialism, a question of post-colonial era, where our public health regulation was really centered around Britain's struggles with Spanish flu for a long time. So the legislation that we had brought into our land emerged from the 1848 cholera outbreak, the Spanish flu situations in Britain. And there was a lot of force, government control, military control, use of security. I think we saw this a lot in the 87-year legislation. And the question has been, how do we move away from the colonial legacy of a legislation towards a modern legislation that we want to think about? It's not just a Ugandan question. I think Kenya had a 1921 legislation that they had to deal with in 2017. Rwanda had to deal with the Belgian colonial era legislation that they had to deal with for a long time. I think Tanzania also went through the same thing because they were also modeled around very colonial legislation, controlling legislation. So it's not just a Ugandan issue, but it's an issue that has been in the region and continues to be in the region as we deal with this. The second point is that as we get into difficult things of non-communicable diseases, how do we begin to legislate for controlling and making sure that things work, including basic things? How do we do public health legislation that requires people to run? How do we do the legislation that requires people to work out without being so intrusive in their rights as they work on? We've seen legislation around HIV/AIDS control, but we still struggle with the principles that were used in that legislation and how we deal with it. How do we answer questions of constitutionalism? The entire chapter 4 of our constitution, how does it play out with compulsory immunizations that we see sometimes, with parental consents of minors and young people in pandemics and situations like that? How do we deal with the questions I've listed of the individual versus the law, as we control the individual, but we also control individuals' businesses? The whole question of governance. At what point in time do we wake up and invoke the government powers? In the pandemic, we made an attempt to actually say the Minister of Health has power within the Public Health Act to regulate treatment costs. And we had got a consent when the minister actually accepted that, yes, I do have powers within the Public Health Act to regulate the costs. And part of this has been the basis for developing regulations around costs. But how do we move beyond costs for COVID-19 to costs on public health issues that will be emerging? And how do we regulate costs amidst the economy that is private sector led, as everyone is indicating, where it's free market economy? How do we highlight public health as non-dispensable, even in a free market economy? And that comes with the financing obligations and the ICT obligations. I will end with just asking a question. I think we have really struggled as a country to make the law. And I know that my colleague Martha will be talking about the struggle with this. The big question for me that has stayed is it possible to build a public health legislation in a new dispensation, but grounded in colonial thoughts? Did we have to just amend the act, or did we have the liberty to throw away the act and build the legislation on purely new principles? Because everything I've said above there are very new to public health, including the legislation that we have. Was it totally possible to do a surgery of an act 90%, retain 10%, but leave the base of the legislation that we have? Allow me stop there and invite my colleagues to give more depth onto the broader subjects that I've introduced. Thank you very much.
A big thanks to Dr. Mulumba for that well presented keynote address. It is raising quite a number of interesting issues. Before the conversation, I was wondering what is the connection between healthcare and public health? So we are talking about prevention and control of disease, that if we don't control the disease, we end up in the healthcare system. So they are quite linkages, but they are distinct. So I've learned that distinction, and I hope the learned friends online have also picked insights. He has raised quite a number of key issues. I didn't linkage between tax and public health, but is raising tax issues when it comes to pandemics. Issues of trade, how do you procure in a pandemic? Are the rules for procurement flexible? How do we deal with misinformation? The approach of legislation. I've seen Mr. Ronald Bagaga on the call of the First Parliamentary Council. What approach do you take when legislating on public health? Do you, if you want to change a law, do you do a total overhaul? Do you amend? Do you have a new legislation? I think those issues will be highlighted by Martha in her presentation. So there are quite a number of interesting things. So before we go into our next presentation, allow me to introduce some of the attendees I've seen online. This will be done concurrent as we discuss. I've seen Mr. Peter Walubiri, I've seen Dr. Mayambala, Mr. Philip Palika, Sharif Kisitu, Salama Nakasi, Catherine Naguta, among others. So we'll be sharing as we continue. Thank you so much for attending. And in case you have any questions, any comments, kindly share them in the chat. They will be addressed in the course of the conversation. So as per our program, we are going to have our next presentation for the day. We have had a general conversation on what the Public Health Act generally means for us. What are those key emerging issues that are critical for us across the sector, tax sector, procurement sector, trade sector, health sector, among other sectors? We are going to hear from Ms. Martha Achan Isabella. She was at the center of drafting this legislation. She will take us through what does it mean in terms of those salient provisions of the law. I was happy to, I was glad to look at the copy of the Act, but the Act repeals some interesting laws, which some of us might not be aware about. There's a Venereal Disease Act. This was an act which had a number of criminal penalties when it comes to venereal diseases. It was repealed. The Immunization Act of 2017 was repealed. So those in the health sector, this act was repealed. So the law applicable is the Public Health Amendment Act. So we'll have Ms. Martha Isabella Achan. Ms. Martha is a member of the Uganda Law Society and the East African Law Society. She's a legal advisor of the National Action Plan for Health Security at the Ministry of Health. She'll be taking us through an overview of the Public Health Amendment Act. Martha, we thank you so much for leading the legal fraternity. I know you work with the ministry, but for us as legal fraternity, we treasure your contribution in trying to shape the public health arena of Uganda. So kindly take over. Over to you, Martha.
Good morning, everyone. I hope I can be heard.
We hear you very well, Martha. Good morning.
Good morning. I'm called Martha Isabella Achan. I'm a legal advisor in the Infectious Diseases Institute, but currently working with the Ministry of Health to support the review process of any public health related law. So you heard Dr. Mulumba mentioning the COVID rules. I worked on those, and I also led the process of the Public Health Amendment. And currently we're also working on the review on the Animal Diseases Act. So all these laws are very relevant to public health. So I'll give an overview of the act as it appears right now. It has been gazetted, and that's a citation on the first slide. I attempt to give a brief on how we carried out this process. The Ministry of Health started the consultations with different stakeholders back in 2012. However, the process stalled because they generally lacked legal expertise on coming out with law reforms. So I was brought on board in 2019, and with the support of the Resolve to Save Lives and several other stakeholders, were able to push this process to date. And in terms of 2020, 2021, we're able to take this law to cabinet. And as was mentioned earlier, a couple of laws were repealed because of this amendment. We repealed the Immunization Act and put the provisions within the Public Health Act right now. We repealed the Venereal Diseases Act because we thought the provisions in there were really unconstitutional and irrelevant for 2023 or 2022, this particular century. However, when we attempted to repeal the HIV law, we met a lot of resistance, and that one's still in the statute books, even if, right, for us, we think it's not a relevant law for public health response. Why did we amend this law? As the Ministry of Health and as government of Uganda, we thought that we needed a law that can actually address emerging public health challenges. And the law was enacted in 1935, so it did have the provisions relating to Ebola, Marburg, COVID-19, and several other zoonotic diseases. So we sought to have a law that actually is open to respond to such emerging public health challenges. Secondly, as a country, we're signatories to the IHR, the WHO International Health Regulations 2005. And we're among the 196 member states, and we have an obligation as signatories to align our public health laws to that particular international law. Also, we sought to amend and update the fines. So the 1935 law had the highest fine as 2,000 shillings. And that really made the law really unapplicable, irrelevant, and obsolete, even for the local governments. So we sought to update the fines, not to make it more enforceable right now. And lastly, as a result of the COVID-19 outbreak, we also introduced express fines. This was among the proposals from the president. I think he must have had this in one of his speeches, his COVID-19 speeches. Briefly, I thought I could have a slide on international health regulations, because for us, it's extremely important in public health response. Uganda is among the 196 countries that are signatories to this particular international law. And we sought to align the Public Health Act to this particular regulations. So with the amendment to the Public Health Act, we shall have to also come up with regulations on how to respond to outbreaks of notifiable diseases. Things like Marburg, COVID-19, Ebola, and other zoonotic diseases that are really affecting individuals around this time in this century. We also seek to amend the regulations on port health. Now, 3/4 of the international health regulations focus on port health, because the main purpose of international health regulations is to ensure that we don't have diseases spreading globally. So the best way to do that is to ensure that you have very good laws and systems at the points of entry, at the borders. So with the amendment of the Public Health Act, we're going to have to review 2 pieces of legislation on the notifiable diseases and also on port health. And then I wanted to mention that right now we have to be very abreast with global health developments happening right now. Currently, we're undergoing the review of international health regulations. The meeting is going on right now. I've been participating in it virtually in Geneva, and we seek to amend the international health regulations in line with what happened during the peak of the COVID-19 pandemic. We're also currently participating in the pandemic treaty negotiations. These 2 pieces of international laws are extremely important for public health. And indeed, they may even have an impact on some of the provisions in the Public Health Act currently. In the Public Health Act, there is a definition of public health, and I thought it would be so good that I mentioned it in this particular slide. It was introduced in Parliament because the parliamentarians thought that it is good for stakeholders to understand what is public health, because the word is used throughout the Act. And we borrowed from the WHO definition, that is, public health means the art and science of preventing disease, prolonging life, and promoting health through organized efforts of society. Now, throughout the amendment, you see we emphasized the mentioning of the local governments and the authority, which is KCCA, because really public health response, public health measures are usually implemented at the local governments as opposed to central government. So public health really results from societal efforts. And this is what is appearing in this particular interpretation and definition. Therefore, public health includes preventing disease. So in the amendment, you come across issues to do with decontaminations, inspections, medical examinations, reporting, fines, proper disposal of dead bodies, hygiene. All these are ways of preventing disease. We also have provisions on prolonging life, what we see as vaccinations. For us as public health practitioners, vaccination is one of the biggest interventions in public health. And there's substantial provision on vaccination in this amendment. We also have a few provisions which were introduced by the Parliament on promoting health, provisions on health promotion. Of course, I think this was a very good initiative because you can't enact a law or come up with a new law in 2023 and you don't talk about health promotion or ways of preventing non-communicable diseases. Very important and very common in this particular amendment is the role of the medical officer. Now, public health, as I mentioned earlier, is really work of the local governments as opposed to having a central government. So we made an amendment to clearly state who the medical officer is, because this particular person plays a very key role in the implementation of this public health law. So the medical officer, for purposes of this amendment, is the one employed by the authority, that is KCCA. That would be the director in charge of health in the KCCA. Then we have the medical officer at local government. They currently call them the DHOs, the district health officers. And then the medical officer at central government. These are the ones who are in charge of the regional referral hospitals. So you see that in section 2E. I shared some documents. One of them is really the amendment, and one I came up with to make the amendment easier to read and to understand, especially for non-lawyers. Another aspect is the medical practitioner.
Martha, we seem to have lost you.
I'm sorry about that. There's a bit of noise in the background. Another person we need to be conversant with is a medical practitioner. For purposes of the amendment, the medical practitioner is a private medical officer. For those working in the case hospital, for example, Nakasero Hospital, IHK, that is a medical practitioner. So it's important as you're interpreting this particular law to be able to differentiate between the medical officer and the medical practitioner. And indeed, in terms of the role of a medical officer, this person plays a very central role. You can see in section 5A, this is the one who actually carries out the role to do with promotion of public health generally. And their functions are not only limited to the Public Health Act, but also to any other laws that have public health implications. To continue on the role of the medical officer, this person can actually enter and inspect premises and persons. Now, you may recall that during the peak of the outbreak of COVID-19 here in Uganda, there were instances when medical officers actually entered to people's premises to examine them. They were working under the section 12 of the Public Health Act. Another a bit controversial provision is on the destruction of contaminated beddings, clothing, or belongings. This role was played very heavily during the EBD outbreak, rather the Ebola outbreak in Mubende and Kasanda. where it was found that it was necessary to actually destroy properties of patients or persons who have actually recovered to ensure that they break the chain of contamination. The medical officer of health is actually also supposed to supervise the handling of bodies of persons who have died from an infectious disease. That is a responsibility we see in section 25. And very important is issues to do with food safety. We did some amendment here in terms of giving the medical officer power to examine food handlers and also prohibit the employment of persons who are working in food-related businesses and are carriers of infectious diseases. That is the responsibility you see in section 105. Another key role in the amendment is on the role of the KCCA, the authority and the local governments. Now, you may wonder where the cities fall. We had several discussions during the amendment process, and we agreed and we understood that the cities will fall under local governments like any other local government. But currently we only have one authority, which is KCCA, and they are creature of law. So the authority has a responsibility to provide conveyances, for example, ambulances to carry people suffering from infectious diseases. You see that in section 18, and to take all measures possible to break any chain of contamination or occurrence of communicable diseases. And they also have a key responsibility to promote public health. You see that in section 5. Another important aspect is to do with One Health. The authority has a responsibility to report to the Director General on Health Services about any unusual sickness or mortality in animals. Now, this is a very important provision for us, for public health practitioners in terms of One Health, to ensure communication between the human health and animal health sectors. And importantly also, the local governments or KCCA can prevent occupants of unhealthy dwellings, as well as prevent working in factories or trade premises that are dangerous to health. You see that in section 56. Okay, and then importantly as well is this authority and the local governments can also close premises that are open in contravention of the Public Health Act. You see that in section 126A. Now, you may be wondering where all these provisions are coming from. We actually had several stakeholder engagements, and these matters were seen as very relevant to the different local governments and to KCCA. And this is why we are emphasizing them in this particular discussion. And importantly as well is the local governments or KCCA cannot be held liable for any act done in good faith and for the purpose of executing this particular act. You see that in section 132. Now, importantly, as we mentioned earlier, this law was enacted, the old law was enacted in 1935, which means that issues to do with decentralization are not covered. So one of the reasons as to why we've not covered this particular amendment is to introduce decentralization into this act. Therefore, you see that the local governments and KCCA will administer the public health, and this is fully provided in the Constitution, while the role of the Ministry of Health will be to make laws and policies and only to respond to epidemics. So you see the local governments responding to epidemics only if the Ministry of Health has delegated that responsibility to the local governments. I think you must have seen with the EVD outbreak in Rwanda and Kasanda, Ministry of Health had to go and actually respond directly. They didn't leave the responsibility to the local governments. They only had to collaborate with the local governments, but the main responsibility was theirs, the Ministry of Health. Then an important provision that was introduced by the Parliament was to do with the provision of medical services. You see that in section 110. Now, this was picked from the Social and Economic Objectives 20 in the Constitution. That is, the state shall take all practical measures to ensure the provision of basic medical services to all the Ugandans. It is already in the Constitution, but for emphasis, the parliamentarians thought that we should have this also in the Act clearly to ensure, I think, the provision of medical services to all Ugandans. Therefore, this particular act has introduced a provision on government's responsibility to provide medical services to the population and to ensure access to health services. That is in section 110A. And as I mentioned earlier on, we have a provision on health promotion. Now you notice, as I said earlier, you can't have a law that has been passed in this century, and actually in this particular year, or last year, for example, that does not have anything to do with provided on NCDs, because right now Uganda is facing a double disease burden of communicable and non-communicable diseases. So this particular provision, section 49, seeks to have some form of responsibility, the Minister of Health, to plan and budget for the promotion of health, and also have in mind wellness programs. I thought this was a very nice input from the legislators. The other important aspect in this particular act is the link that we put between the local governments and the Ministry of Health. Now, since the Medical Office of Health is appointed by the District Service Commission, there is no responsibility or obligation on their part to actually work very closely with us in the ministry. However, we put a provision in this amendment to ensure that the medical officer of health is required to inform the DG of any disease outbreaks. And this link will work very well for us because that's one of the ways we ensure efficient response, right from the village health teams to the health centers up to the DHO, then to the DG in the ministry. And indeed, the medical officer can carry out practical measures for prevention of diseases or disease outbreaks in consultation with the DG. A key addition to the Public Health Act was in relation to the Advisory Committee of Health. Now, you may have noticed that during the peak of the COVID-19 outbreak, and not only the COVID-19 outbreak, but also during the EVD response, Ebola response, we had several committees being mentioned. There was one in the ministry called Strategic Committee. The other one called the National Task Force. The legislators, the parliamentarians thought that we should actually have a legal basis for these committees. Therefore, they tasked the Ministry of Health to come up with a provision that really focuses on these particular committees. And this is the provision. So we amended that particular provision and came up with a committee that will provide expert guidance on responses to specific public health events. Therefore, this committee can be set up with experts on malaria, if there's an outbreak of malaria, with experts on respiratory diseases, in case we have to respond to those like COVID-19. And this committee can actually give advice to the minister on prevention and control of public health events. Another one that could be very necessary and important for us lawyers is on contact tracing. It's a controversial one, but for us in the Ministry of Health and indeed in outbreak response, at some point at the peak of the COVID-19 response, we realized this provision had to be amended thoroughly because we faced problems of contact tracing. As you respond to disease outbreaks, there's that stage before the disease becomes prevalent in the communities, whereby contact tracing is extremely important. This provision refers to compulsory release of personal information, okay? And it's aimed to ease the process of tracing for the source and preventing the spread of any infectious disease. You see that in section 27, paragraph R, S, and T. And then also importantly on funeral homes, when we're carrying out the consultations on the amendment of the Public Health Act, we learned that there's no law in place that is actually regulating funeral homes. We were told that if we want to set up a funeral home, they really need to just come up with a trading license. And yet, one of the ways of controlling public health events is to ensure that you have proper disposal of human remains. Therefore, the Minister of Health has been empowered in this particular amendment to regulate funeral homes and mortuaries. Therefore, the medical officer will implement the rules to ensure proper disposal of human remains. Another really interesting, and this particular part got a lot of interest from the public, was to do with immunization. As I said earlier, we repealed the Immunization Act because we thought it was double legislation, having a subject of public health out of the act. And yet actually the act at the time had a chapter on immunization. And then again, we had an act on immunization. So we sought to repeal the act and bring the provisions back into the Public Health Amendment Act. Therefore, there's a particular matter which I thought I could mention of interest, matters to do with mass vaccination and revaccination. This is where the provision to do with the mandatory vaccination was input. And due to the public outcry and also from the reaction from Parliament, we failed to have a provision on mandatory vaccination. Now, currently, if we have an outbreak of a disease in Uganda at the moment, the minister can only gazette the notice and then also post the notice in a newspaper of wide circulation and request residents to be vaccinated or revaccinated. That is section 47. Of course, this particular provision has its disadvantages because right now we're already facing a problem with mumps, an outbreak of mumps in children. And yet, for example, in the Kampala region, you can't have KCCA forcing schools or parents to bring their children for MMR vaccination because of this particular provision. But due to public outcry and also due to the arguments of Parliament, it is now not mandatory, can only be at the decision of the citizens. In terms of vaccine efficacy, government has a responsibility to work with an NDA, National Drug Authority, to ensure that the vaccines that are issued are free of charge and also safe for use. Another one that we picked actually from the Immunization Act was on misinformation about vaccines. Any person who publishes any information about vaccines commits an offense, and they'll be liable to pay a fine of 50 currency points, that's about 1 million shillings, and imprisonment of not more than 6 months. Another important provision on vaccination, I'm leaving out some parts because they may not be so relevant for us as lawyers, issues to do with vaccinators and child vaccination. But we have also made sure that there are provisions to ensure vaccination of persons in prisons, in mental health facilities, and also importantly, there's a provision to ensure that no child can be admitted to a daycare or primary school or primary without producing the vaccination card. Now, in terms of mandatory vaccination in children, I think it is too mandatory. Provided the provisions, I think it will be up to you to really interpret them, but for children, it is too mandatory. As I said earlier on, one of the reasons why we decided to have this law amended was the fact that the fines were really very low and obsolete. And so, as you can see, the fines were amended, and now the highest fine in the Act from 2,000 shillings to now 50 million shillings. You find that in section 36.3. This particular fine is for companies that break port health regulations. We had many of those during the peak of the COVID-19 outbreak. We had companies that export labor, and they were allowing their staff, their employees to travel to some other countries, like in the Middle East, with forged COVID-19 certificates. We deregistered many of these companies as we're working with the Ministry of Gender, but now we have a provision in the law currently. Such companies will be liable to pay a fine of 2,500 currency points. I already mentioned this, express fines. This was introduced on the insistence of the president, and we shall see how we can come up with regulations with the support of the minister responsible for internal affairs. With that, I would like to thank you for listening in. That is all I had to present. Thank you very much.
Thank you, Martha. A round of applause, a virtual round of applause to Martha for the wonderful presentation. I have a picture of what the law is about, and I think we need to read that law and dig deeper into the issues that have been raised by Martha. She raises quite very interesting issues which I didn't know about. The ongoing conversations, global conversations on the amendment of the international health regulations. Maybe we'll get to know later on how do we as lawyers make a contribution to such important initiatives, the pandemic treaty negotiations. Again, we we may need to know later on how do we make a contribution to the pandemic treaty, because at the end of the day, the treaty will be applying here. So we need to see how we can make a contribution. I know there are members here who represent local governments. The law seems to put a heavy burden on local governments in terms of implementing the public health measures. So it might be important for the legal fraternity here which represent the local governments to read deeper those provisions that give mandate or put responsibility to local governments to implement the public health legislation. Issues of food. There's also there's a group of practitioners who venture in the area of right to food. Issues of food safety and moral health also are catered for in the law. As a legal health practitioner, I was intrigued by the new provision that gives legitimacy to the right to health, where government has a responsibility to provide medical services to the population and ensure that health services are accessed. I think this is very important for those in the government sector, especially the lawyers representing government in the different sectors, but also for us who practice health and the law. This provision is, I think, very important for us as we push for rights of our clients. Issues of funeral homes. Currently, I don't know who holds them accountable. If we have that legal gap, maybe Martha will come in later on, maybe to paint a picture of when the regulations can be in place, because they're operating without any form of regulation. And we are happy that it was an area of consideration in the Amendment Act, but we need to know who holds them accountable. How are they operating without regulations? I think it can be important for us to know, because there are so many cases coming out of that arrangement. Vaccinations, vaccine efficacy. I think we'll have a conversation by Dr. Chiliro on vaccine issues. I think he'll elaborately explain and talk about the issues. So again, Martha, we thank you so much for raising those important questions. Those that are online, if you have any questions, we have a Q&A. You can raise your questions there, and you can even share in the chat. We'll be noting the questions, and we'll be forwarding them to responsible panelists for a response during the plenary session. So our next presentation is a very interesting one. We've been talking about the law. We've been talking about public health. We have Dr. Chibira Dennis. Dr. Chibira Dennis is a pharmacist, but has a PhD in pharmaceutical production. He's a global public health practitioner and expert. He's a coordinator of Uganda Medicines Transparency Alliance, which is called META. And he has been in the field of health and the law for quite a number of years. He sits on a number of committees at WHO, Ministry of Health, and NDA. So he's best placed to take us through emerging issues on ethics when it comes to implementation of public health measures, issues of vaccine hesitancy. I think we'll be bringing them out, issues of vaccine equity, issues of vaccine efficacy. And interestingly, Dr. Chibira, as you come in during COVID, it was the first time to see a vaccine being put on the market without going through an elaborate procedure. We know of clinical trials, and we had to rush and get it. And issues of efficacy and issues of ethical considerations when developing these vaccines for during pandemics become very pertinent. And we know that all over the world, some people had complications, blood clots, and the rest of the complications. And some are linking it to the rush of the vaccine, but we needed it. So take the floor and take us through those ethical considerations. Dr. Chibira, welcome. Thank you.
Thank you, my land colleague, Ibrahim Sereko. Sorry for calling you my land colleague, but I hope that by the end of this session, that land colleagues here will also include me as a land colleague. I'm happy to be here speaking to the members of the Uganda Law Society. So thank you for the invitation. I'll request to share my screen. I have a presentation. Maybe now that people have seen my face, I should just stop the video. So the slideshow is taking longer to load. I don't know why. But I hope you can hear me, and I hope you can see my presentation.
We hear very well, Doctor.
Yes.
We hear very well, and we see the presentation. Kindly proceed.
Thank you very much. As introduced, my name is Dennis Kibira. I'm a pharmacist by background, but I've spent many of my working years in civil society, working to ensure access to essential medicines through research, policy advocacy, and multi-stakeholder coordination. And I'm the national coordinator of the Medicines Transparency Alliance, the chapter of Uganda. I was, until recently, the executive director at Health Human Rights non-government organization called HEPS Uganda. I'm now the CEO at Dumake Global Health. And at Dumake, we work to strengthen the health system through innovative global health research, capacity enhancement, and policy engagements. I want to talk to you a little bit about ethical legitimacy on public health measures. And I probably will not speak too much as a lawyer. I speak a lot through my experience. So ethics. Ethics comes from the Greek word ethos, which means character or custom. And ethics equate to individual character and social rules. And these social rules govern and limit how the conduct of society. They set what is right and what is wrong. And ethics is a field of study for what is called morality. And as we all know, morality looks at the individual's conduct and the values of society. And moral standards set out what the norms and values of society are. And these are really aimed at and protecting and promoting human welfare. And as you will see from the definition, which has come out from both Dr. Mulumba's presentation, but also from Isabella, about public health. Public health is also not, these are one of the same thing, because human welfare, which morals aim to protect, is also what public health aims to is what ethics also aim to protect. And ethics really conventional things like maybe against lying, against stealing, against murdering, and how to deal with those issues so that the society is not hurt. And it's aimed at treating a human being with dignity and respect. Hence, the promotion of life becomes the highest moral standard that we aim to attain as humans. When we continue on to public health, public health interventions typically aim to create or promote particular public health benefits, or to avert particular harms, or to protect from harm. And but they also come with some costs, and sometimes they have some harm. So sometimes also implementation of these public health measures can infringe on individual freedoms. And so that's why there is need to have ethical principles to guide public health measures. And I think, as Nsereko said, I want to focus a lot on COVID-19 and how it changed this entire public health, our entire public health space. You saw that if we can flash back to March 23rd, 2020, and the case of Uganda, that speech at 8 p.m. By the Fountain of Honor, the president, where we were all glued on our TV sets, and we were told that by 10 p.m. that night, we were supposed to stop wherever we were and park. So a lockdown ensued. The borders were closed. Schools had earlier been closed, and anyone that was to come into the country at that point, there had to be testing, as these are routine measures for any pandemic. You have to test, and you have to quarantine for 2 weeks. And then there was contact tracing, which was also a very difficult one. I've just gotten into the country around the time that lockdown was instituted. And I spent the next couple of months waiting for a phone call in terms of contact tracing, in case anyone had fallen sick from my flight. And so this was difficult for all of us. The social distancing, I don't know why it was actually called social distancing, because we are social beings, and being together is one of the things that humans cherish. I don't know why, maybe it should have been human distancing, but it was called social distancing. And so many of us spent the next couple of weeks really scared and locked up in our houses. I think it was 3 weeks. And then it's until the president came after 3 weeks and announced that the lockdown was to continue for another 3 weeks that many of us got agitated. I remember moving out and seeing people on the road. But if you actually, the lockdown was mostly for those that were not earning hand to mouth, because other people felt that, well, they would rather die from corona than die of hunger while their children are looking at them. So some of these were the issues that that were seen, people struggling to make a living for themselves because businesses were closed down, movement was shut. And what we saw, again, when the essential groups came in, some that could move, some that could open businesses, whereas coronavirus was, it was said that this is a disease mostly affecting the old and vulnerable, and it was mostly for people indoors, those that had air condition and were indoors. So for some of these measures to a layperson, they didn't make a lot of sense, because for, say, a country like Uganda, where more than 50% under 15 years of age, and where people are mostly outdoors in gardens, this didn't make a lot of sense, because this seems to have been focused maybe on another context elsewhere. And then, of course, where some essential groups were allowed to move. And then, of course, we saw in areas like Nigeria where cars were, there was even traffic jam. So you remember Boris Johnson holding a party in Downing Street, which actually caused him a lot of political troubles. So some people felt that some of these rules were not for them. And then if you look at number 4 there, how when some medications came and also the vaccines, how there was a struggle between the rich countries. And then the rest of us were left to wonder, okay, where shall we go? But then when we managed to maneuver through and the mortality was not as expected in our low-income countries, but also with the anti-vaxxers and a lot around vaccination on social media, saying that, well, this is a fake crisis, this is a disease for the rich. And this was also exacerbated by some of the policies that we also saw that seemed to favor maybe some people against others. And so, of course, society forms their mind up on how to go about some of these things. And so when we were struggling to buy vaccines for the country, you remember Parliament appropriating funds, but then we couldn't even go out to buy. We had to buy through middlemen. The prices that were quoted for Uganda were also about 2.5 times more expensive than the Europeans were getting. And so we had to rely on donations, some of which came in with short expiry, and then we were rushing to get this. And then some people said, I think we can do without these vaccines. First of all, the testing was too expensive. The people that tested, maybe if you had to see the president or to travel out of the country, you needed to pay for a test at 200,000. How many Ugandans can afford 200,000 shillings to pay? And so this was seen as maybe a disease for the rich, for those politicians that maybe have to go to parliament or who hope to see the president. Many Ugandans were not in this class. Also, issues around the vaccine. Of course, a vaccine usually takes 10 to 15 years to produce, and we had a vaccine in a period of a year, and many people were saying, no, we do not trust this. Many had unfortunate incidents with their children. Some children had died of after taking some of these routine vaccines, and so there was some hesitance in the community about this vaccine, but also not a lot of information went out into the communities about these vaccines and how safe they were. And so people decided to keep a distance. We're actually now struggling with millions of expired COVID vaccines, but that's a story for another day. So I think COVID really brought out the issues of ethics in handling public health measures. There is formulation and also implementation. And there are principles. There are principles for this. The 8 principles in total, and some of these is that there should be evidence, and this should be provided to the community. Evidence of what will be the benefits of this. So if we want to be locked up for several weeks, it should be, people should clearly see that there is potential for them to benefit out of that. But also there is need to show that the least restrictive alternative is taken. We know from previous public health. You know, COVID-19 defied most of the previous public health measures, because as we know, that restrictive public health measures were found to be counterproductive. And so, but with COVID-19, of course, we had to bear with the police lockdowns, with staying at home. And so there has to be, you have to take the least restrictive option and give people liberty in formulating any public health measures, but also the least harmful alternative. And this doesn't just look at, just the public health, but the harm to the society in general. We saw, and we're still struggling from economic downturn due to COVID-19, but also what are the other potential harms that a disease like that could have brought, not besides school children, a number of teenage pregnancies, the number went up, as we know, in Uganda. Children lost a year or two in school, whereas the children of the elite were studying online, the children in the villages were out hunting for snakes. So there has to be a balance. And then proportionality, again, you have to weigh the harms and the burdens against the benefits. And there should be equity. Any implementation of an intervention should be in such a manner that there is non-discrimination, but also that the beneficiaries of interventions should be able to compensate those who are burdened. And I think civil society has been in arms for many years, talking of a tax on for smoke cigarette companies, the harm that comes through smoking, and then the taxpayer has to meet people that will burden the system, say from lung cancers. And so, is there reciprocity? And then there should also be a due legal process that individuals should have a way of having redress, but also that these policies should be done in a transparent and accountable manner. These measures really are meant to, first of all, for the well-being of society, the values of fairness that should be considered, but also freedom is really important in having these measures formulated and implemented. So a number of frameworks, ethical frameworks, which have been put up since the 1990s, and these range from the 8 principles I've talked about. Others are based on human rights and social justice, and others are based on political philosophy. But I've selected Mariki ten Hav's framework, which proposes, which lays out 6 frameworks for public health professionals and policy makers. And these are the CAS framework, which aims to raise awareness of ethical issues of proposed programs and to help consider means of responding to them. And this framework also includes an analytical tool, which provides a step-by-step list of 6 questions for deciding how the burdens and benefits of an intervention can be fairly balanced. There is the Childress framework, which provides a conceptual map of public health ethics and attempts to resolve conflict between the promotion of public health and moral values. There is also one by the Public Health Leadership Society, which provides a code of ethics for public health institutions. And there is the Eurofen, and that's for the European Union, which provides approaches to public health policy. And this framework also provides an analytic tool that sets principles and values and examines normative issues that should guide public health programs and their implementation. And then there's the Unified Council on Bioethics, which offers two analytic tools, the stewardship model and the intervention model. And the stewardship model describes acceptable goals and restrictions for public health policy. And there is the Tanner-Hills framework, which provides a decision triangle, setting out ethical principles that should guide whether to implement or not to implement. But these frameworks have been maybe they've been formulated elsewhere. And I think we could also come up with frameworks as African countries. And I was reading the PhD thesis of Dr. Mulumba that sets out a framework to promote community participation in health systems. And he talks about mostly also around the same things, utilization of the human rights framework, harm reduction as a key component, direct participation through selected leaders, gender considerations, empowerment, and looking at partnerships, but also looking at inclusion and non-discrimination, and most of all, transparency and accountability. So we need to have, in any public health policy, so these ethical measures certainly need to take forefront. And this is so because if they contravene what society takes out as to be right, then their acceptance will be affected. And as I've shown, tools are available for this to guide decision makers. And this is crucial for you, our lawyers, because you're custodians of law. And so you should probably look into this and see how you've been formulating your law. But then sometimes these are mostly, they may not be very practical. They may be on paper. These tools may not be so practical. And so there is need to contextualize them, and there is need to engage stakeholders. I'm happy that when Isabella was amending the Public Health Act, that there was lots of consultation. I think I'm also one of the people that was consulted. So that's it, Chair. This is some of this where I've gotten some of the material that I've shared today. Thank you very much, and I'm happy to take any questions.
A virtual hand clap for Dr. Shibira Dennis. The subject he has touched is very critical. Even as we practice the law, we find ethics very, very critical and the center of legal practice. Likewise, in public health, ethical considerations are very critical if we are to implement public health within the rights framework. So he has raised quite a number of interesting issues: vaccine hesitancy, vaccine equity, and the implications when we don't observe the ethical considerations, but also the ethical models that are critical if we are to enforce and observe public health. So what has raised points to quite a number of interesting aspects that are going to be discussed in our next topic. It has raised vaccines. When you talk about vaccines, you talk about innovation. And when you talk about innovation, what comes to mind is rights. How do I get intellectual property rights over an innovation or of a vaccine? So Dr. Paul Ogendi will be discussing the interaction between intellectual property law and public health, and how does this connect to the advancement of vaccines and pharmaceutical manufacturing in Africa. When Dr. Chibira was presenting, he made a comment which has kept me thinking that as countries in Europe were accessing vaccines, we were begging for vaccines, we were at their mercy. So Dr. Paul Ogendi's conversation will again provide insights on pharmaceutical manufacturing in Africa. Dr. Paul Ogendi is a lecturer at the Faculty of Law, University of Nairobi. He's an advocate of the High Court of Uganda. He has done a lot of work in the field of intellectual property, access to medicines. And Doctor, if I've left out any credential which you think is critical to share with the legal fraternity in Uganda, I think kindly share. But we are happy that you have joined us in the conversation, and the floor is yours, Dr. Ogendi. Thank you.
Thank you very much, my friend and colleagues. I'm happy to be part of this particular important discussion, which I think is timely, and good job to the team in Uganda. Just a slight correction, I'm the advocate of the High Court of Kenya. Of course, I am allowed to practice in East Africa as well. So first of all, I think I will adopt the methodology used by Moses. I will not do a presentation, but I will try to do a lecture. And the lecture will focus on three things. The first one is I want to give you an overview of the intellectual property TRIPS flexibilities, just to define them. Then I'm going to discuss the issue of local production of vaccines. And the good thing is that now governments are taking seriously the policy and legal landscape, because in the past they wanted to rely on India and these other companies abroad in developed nations. But the experience in COVID has taught us that you really need to at least have something in your country or near your country. So that is what we call diversification of production of vaccines, or local production of vaccines, depending on where you stand. Then the last thing I will do is I will try to look at the initiatives of the WTO and the WHO. And of course, we'll make a mention of what is happening regionally. So to get us started, you will realize that when we talk about local production, usually there are three elements involved. There's the economic aspect, which is involved. There's also the infrastructure aspect, and these are issues Dennis Chibira can discuss at a much higher level than I can. But where I come in is the legal aspects. So the legal aspects we are talking about here usually are about technology and the protection of technology. I am glad I'm talking to lawyers, because I find it very hard sometimes to explain some of these things to lay persons or community people. But in law, you realize that one of the laws that are used to protect technology is intellectual property rights. This is the framework that is used to protect technology, both the product and the process. Now, over the years, the IP has grown in stature, And now even we have an international instrument, which we call TRIPS, or in long format, Trade-Related Intellectual Property Rights Agreement. Now, under the TRIPS, we have what we call the minimum standards, or if you are from the other side, maximum standards that must be implemented by every country. Now, there are important things to note in the TRIPS agreement, that in as much as it provides for rights, and that is where the industry or people involved in production of vaccines really pay much attention. And many programs in the universities usually focus on this aspect more than the other. The resulting, in the document as well, we have what we call flexibilities. Now, if you're a public interest IP lawyer like myself, my task is always to look at what are those flexibilities and how can the government take advantage of them, because that is where the policy develops from in terms of local production of vaccines. Now, there are about 6 or 7 flexibilities. I'll mention a few of them. And the first one that I want to start with is the exhaustion or parallel exhaustion principle, which is important when you talk about parallel importation. Now, here, what we mean is that goods which are legitimately placed on another market may be imported from that market without permission of the rights holder because of the exhaustion of the patent holder's exclusive marketing rights. I am in Kenya now. If a patent holder for a medicine puts that medicine in the market, let's say in the local shops, you as a Ugandan do not need further permission to buy that particular drugs from my shop because the patent holder has exhausted that particular patent when it hits the market. So that is what we call exhaustion and parallel importation in particular. That is one important flexibility, and it has worked well, particularly where you have drugs which are very expensive in your country, but you can find affordable or cheaper market outside your country. So in America, for example, people go to Cuba or Canada to be able to buy the same drugs that have been prescribed, but they are very expensive in the US for one reason or the another. The second flexibility I want to discuss with you is the patentability criteria. So this is the criteria you need to implement when you are considering patents. So this is contained in Article 27 of the TRIPS. And what this means is that WTO members may develop their own definitions of what novelty means, because there are 3 criteria: inventive step and in industrial application. So those are the 3 criteria that you need to meet as an innovator to be able to get a patent. So here, the TRIPS agreement flexibility we are talking about is that you can develop your own definition. The other thing that you can do is that you can also refuse to grant patents for certain subject matters, that is plants and animals. In the past, there could be exemption in the pharmaceuticals sector, but that has now been overtaken by events. The only place you can refuse to grant patents is in the area of plants and animals. Now, another important exemption is the Ebola exception, which is provided for under Article 30. And in this regard, the WTO members may provide limited exceptions to the exclusive rights conferred by a patent, provided that such exceptions do not unreasonably conflict with the normal exploitation of the patent and do not unreasonably prejudice the legitimate interest of the patent owner. Here, what we are saying is that you can be able to, for example, start early to prepare production of vaccines, as long as you do not release them in the market. But as soon as that patent expires, you are able to release your product in the market on time. So this particular exception allows you to start production early enough, even before the expiry of the patent, but it does not allow you to release it in the market. So it will be you'll be waiting for the patent to expire, and as soon as the patent expires, you will be ready with your product and you'll be able to release it in the market so that people can start enjoying the benefits as soon as possible. If you look at Article 31, which is the next flexibility, and this is very important in the context of vaccines, is Article 31 on compulsory licensing. Here, a non-voluntary license. Non-voluntary means that you can, as a rights holder or patent holder, license somebody voluntarily, but in this case, a non-voluntary license may be granted by a duly authorized administrative, quasi-judicial or judicial body to a third party to use a patented invention without the consent of the patent holder. However, you must provide payment of adequate remuneration in the circumstances of each case. And there are also other conditions which always are imposed about which market can you supply this particular product that you've non-voluntarily acquired their license. And most of the time, you are encouraged to, through law, to do domestic supply. And of course, through amendments to the TRIPS agreement, now you can also supply to low countries with low manufacturing capacity as well. The same is also government use, Article 31, government use order. In this case, it's not administrative or quasi-judicial or judicial organ, but the government authority, which decides to use your patent without consent of the patent holder for public, non-commercial purposes, subject to the payment of adequate remuneration in the circumstances of the case. So here, the condition of public, non-commercial purpose is very important to note. We move forward to Article 40, and this is where we have competition-related provisions. Here, what we say is that you can actually issue compulsory license if somebody has anti-competitive conduct and control of anti-competitive licensing. So when somebody does not respect competition rules, you can use compulsory licensing to try and correct the behavior in question. There's also Article 33, which stipulates the patent term. And the patent term here is that you are allowed to give a maximum time. The term of a patent is the maximum time during which it can be maintained in force. So in most cases, we are allowed under the Kenyan provision, for example, 20 years, but there are always attempts by pharmaceutical companies to have other patents registered just before the term ends, and that is what we call the evergreening of patents. So if you have maybe Panadol, after some time you'll get something to do with Panadol Extra, and after some time you'll get something we call Panadol Super, and it will continue perpetually. So that is where we have problems as policymakers and people interested in access. Then there are also flexibilities in terms of procedures, and one of them is patent term opposition. Patent term opposition is that in the TRIPS agreement, most of us provide for opposition of that after you've granted patent, but you are allowed in TRIPS to also provide for before somebody has been granted patents, to do what we call pre-opposition, pre-grant opposition. And then we have the revocation, which can be done later after somebody has been given. Then lastly, there's a right of a prior user. So a prior user is somebody who has been using the technology you patented before the patent was filed. So that person is allowed to continue using the technology, and that right is protected in the legislation. Some of the RP provisions, I'm not aware about the Ugandan one, but some of them do not provide for it. But in Kenya, we do have that under section 56(1). Now, that is an introduction, which is supposed to make you comfortable with some of the terms I will use. So when I talk about TRIPS flexibilities in the context of pharmaceutical production, local production, this is exactly what I mean. Those things that I've discussed with you in the last 10 minutes is exactly what I've been talking about. Now, on local production, there has been a great concern, especially in low and middle income countries, for many decades about how do we do this. And like I mentioned before, the tendency has always been to rely on other countries, including India and developed countries, which has very high technology and companies that are capable of doing this. But this view changed drastically when the COVID-19 struck. And what came about, even in, not just in low and middle income, even in high income countries, the contemporary debate on supply chain resilience have led to calls for localization, or at least near-shoring or friend-shoring of pharmaceutical supply chain. So if you look at the EU pharmaceutical strategy, for example, those particular terms have been used. You need somewhere in the context of a pandemic where you can easily get your supplies if you need one. In Africa, we had to wait for the rich countries to first vaccinate their people. And that experience led to many deaths which could have been avoided, even though the nature was kind to us not to kill many of us as in other jurisdictions. So local vaccine production has the potential to provide multiple benefits, including increased supply and accessibility, increased competition, lowered product prices, local job creation, biotechnological innovation, increased resilience through diversification of supply chains, among others. Additionally, it can also address global health disparities and reduce healthcare costs. So you can see the potential impact that, or the potential benefits that you can achieve if you think about local vaccine production. Now, currently, the global vaccine production and distribution is an oligopolistic industry. In other words, there are few companies which are engaged in this particular endeavor, and these companies are creating high barriers of entry and expansion for small local manufacturers. And then this, because of the barriers of entry and expansion, we have the problem of economic viability of local manufacturing. So if you want to access the market, you find barriers placed by oligopolistic industry, and that makes the economic viability of those ventures not attractive. So there's need to have a discussion on the types of policies that you are adopting, because we can address the barriers through the policies so that we're able to increase local production, focusing on what we are seeing recently. You will be shocked to realize that 80% of Africa's needs for medicine are imported, okay? So Africa has 80% importation of all the medicine it needs. That includes vaccine. Now, what this means is that because we rely highly we have very high prices because imports require long supply chains. Okay. And therefore, Africa patients pay among the highest prices in the world for their medicines. So you can imagine if you are to import medicine from America, you will have to include the cost of clearance and forwarding and transport and all this. So those are additional supply chain costs, which are paid by African patients. This is not the same all over the world. Now, moving forward, there is commitment from African governments to support pharmaceutical manufacturing, and this is sustained, but it is underfunded. So there is a lot of intention to do that, produce locally, but there is no funding for it. So the first commitment to a pharmaceutical manufacturing plan in Africa was made in 2005. And then it was followed by a detailed strategy document, which was co-developed by the African Union Commission and UNIDO in 2012. And this document identified numerous challenges for pharmaceutical production on the continent, including cost finance, cost of implementing good manufacturing practices, small markets, and difficulties in recruiting appropriately trained personnel. So these challenges, some of them will be addressed by the creation, with the creation of the African Medicine Agency in 2021. And now there's an approval from the African Development Bank in 2022 of the African Pharmaceutical Technology Foundation. So we see a very sustained move, especially in 2021 and 2022, towards addressing the challenges identified in the manufacturing plan, which was done in 2005. And then the strategy developed in 2012. So we are saying that, and that will be something to watch. So in law, what we know is that it is not just intellectual property rights that we'll have to do. We'll also have to look at licensing requirements, and that is what we call regulation, or regulatory barriers, competition laws and regulatory norms, which impact knowledge sharing, technology transfer, contractual liabilities, and quality control. So in the absence of a global reputation for safety and efficacy, local demand and market alone will probably not be enough to make the facility viable for a long period of time without government external support. So you cannot rely on market alone or local demand to be able to make this available. The government has to play important role to support this sector. So I think I've already mentioned the need. In conclusion, we need to highlight the importance of aligning domestic framework with international mechanisms, e.g. using existing flexibilities to support industry policy, which can improve access to affordable medical products. And then we also need to explore regional integration as a tool to expedite localization, for instance, through regional regulatory harmonization, pool procurement, skill development, and other regional strategies. So the African strategy I've mentioned above is part of this approach. Ladies and gentlemen, I think for me, this is all I had for you. You are free to ask me questions later. Thank you very much.
Thank you so much, Dr. Ogendi, for again, that's an insightful presentation on intellectual property and how this is linked to pharmaceutical manufacturing. Doctor, before maybe you take leave, lawyers that are in this training would like to know what are the opportunities when it comes to local vaccine manufacturing. I know you elaborated, talked about intellectual property and how we can reap from the flexibilities. But for a lawyer who is on the call, what are the opportunities that they can tap into when it comes to local vaccine manufacturing?
Yeah, so mention that we need to focus our expertise, skill development in some areas. The first one is intellectual property. The licensing, that is mostly contracts govern licensing, competition laws. You need to also understand competition laws, and then regulatory norms. Now, this has an impact on knowledge sharing, technology transfer, contractual liabilities, and quality control. So this, if you are able to develop expertise as lawyers in those areas, you are now able to participate in the process of coming up with the sustainable laws and policies that are going to make it viable to have local production of vaccines in the country or near your country. Thank you.
Thank you so much, Dr. Gendi. So we have had 4 heavy topics. I don't know if anyone has a question or comment at this point before we descend into our next set of presentations. Do we have anyone with a question or comment to make? You can just raise up your arm. We'll be able to pick you, and then you raise your question or comment. Yeah. No comments? I've just seen a question here from Robert. Robert is appreciating Dr. Mulumba Moses for the good presentation. Dr. Mulumba, I think this is a compliment for you. Again, Robert has a question on the presentation about the overview of the Public Health Amendment Act. Thanked Martha for the good presentation. However, has a question on the issue of mandatory vaccination to children. And he's wondering whether consent is sought from their parents before vaccination is done. And this is premised on the ground that this is intended to avert dangers arising from vaccination. So that's the comment. Martha will be joining us later on to respond to that question. So we're going to have a break of 5 minutes, then we resume and continue the presentations. Yeah. have to be a part of this important conversation on the legal implications of the Public Health Act. So we will have a conversation on rights. In the course of the discussion, there have emerged quite a number of rights issues, striking the balance between freedom of speech, but also sharing information, which is labeled misinformation, issues to do with vaccination of children, issues to do with security measures when it comes to implementation of the public health measures. So there are quite a number of interesting things. So this session is going to be facilitated by Ms. Nachibuka Nuru Musisi, who is a Deputy Executive Director programs at the Center for Health, Human Rights and Development, CEHAD. She's a lawyer. She has worked in the area of health and advocacy for almost 15 years now. So she has experience on the views, especially when it comes to public health and human rights standards. So Ms. Nachibuka, she's going to be taking us through our next session. Ms. Nachibuka, are you ready to start? Yeah, so she's
Sorry.
joining.
I'm sorry. I needed to get the unmute icon, which I think the controller hadn't allowed me to unmute. First, allow me to appreciate the speakers, but also the participants to this important session where we're discussing matters of public health, but also matters of law. All right, thank you. I think we had glitches here and there in terms of what session I'm coming in. So I'm glad that I'm joining a team of lawyers to have a conversation about matters of health, but also which are important matters of law that perhaps we never get an opportunity to discuss while in law school, but most times get to have these conversations or face conversations while in practice. So my session will really focus so much on the human rights-based approaches to public health. Just to give a bit of background, first, I really want to appreciate the government of Uganda through the Ministry of Health for taking an opportunity to look through Uganda's Public Health Act, which was almost very archaic act to what we see as developments on public health in the country, to have it amended to what we now have as the Public Health Amendment Act of 2022. So I really want to appreciate that ministry for taking forward that. So in terms of human rights-based approach, it's important to understand that a rights-based approach to public health really would focus on health in its entirety, including the underlying determinants of health. And the underlying determinants could be economic, could be political, could be social systems that determine health status. And these really have far greater impact on health than just the provision of medicine. So where we have an understanding that health vulnerabilities are socially structured, public health systems can then be seen as coming in to protect and promote health in its entirety. So our Public Health Act, as we have, has questions on its having of a human rights-based approach. First, Uganda as a country is a signatory to various international instruments And I think we really need to commend the UN for the frameworks that we actually use as a country, or should be using as a country as we develop our own legislations. For example, the United Nations Committee on Economic, Social, and Cultural Rights took a lead in developing a modernized right to health consummate understanding. And I think many of us are knowledgeable about General Comment 14 of the International Covenant on Economic, Social, and Cultural Rights. And if I could just really quote a bit of that, it does not confine the right to health to just care, but it does kind of draft and express the wording, and I think under paragraph 12.2, to acknowledge that the right to health embraces a wide range of socioeconomic factors that promote conditions in which people can lead a healthy life, and extends to the underlying determinants of health, such as food, such as nutrition, such as housing, such as access to food and potable water and adequate sanitation, among others. So as a country that has signed on to these instruments, the understanding is that we would have such a legislation that is kind of wider beyond just health. So, and you may already know that Uganda as a country does not have a very specific legislation on the right to health in itself, and neither that the Constitution specifically have a specific provision on the right to health. We really rally behind national objectives and directive principles of state policy, as well as articles like 45, like 8A of the Constitution. So the development of the Public Health Act was a really huge opportunity for us to think about rights-based approaches in taking forward such an application. Perhaps it should have been one overhaul legislation that actually supports the country into health. So when we speak about rights-based approach, we really think about five things, and usually refer to these as panel principles. And the principle of P requires participation, and participation is a constitutional right. So ideally, we should have had an opportunity where we allow all sectors that have an impact on health participate in the development. I know we tried, but somehow I think the window of participation of various entities perhaps was a little minimal. And being that we are developing or amending a law that was supposed to come in to think about what we would see as health in our sector, perhaps we should have provided much more time for participation. So again, the human rights-based approach requires non-discrimination when we are discussing about health. And I think, of course, the Constitution is very broad in terms of non-discrimination, but perhaps we should have had more concrete conversations on what sectors of health would benefit from the Public Health Act as is, and ensure that we are not discriminating any person to indicate. Of course, the wording of the Act is a bit broad for us to think that everybody's into there. So we ought to have thought again about legality of the law. I'm very certain we are not bad here, because we were amending a law that was extremely archaic and taking on a one-sided approach and not the other. And I think what we have today is a bit a very good legislation that does not really focus on only communicable but also non-communicable diseases, which we really need to think of. Appreciate the government for. In terms of empowerment, I think, again, the Public Health Act, and especially that it was coming in after COVID-19, and I appreciate the fact that we've had conversations about COVID-19. Perhaps it was an opportunity to think and rethink, because what we had, the Public Health Act, the old one, I think 1950 something, we should have thought about what the implications of COVID-19 have been, and what, 1935, I think, and what we should have now broadened to understand what it is. Why? Because while we were struggling with COVID-19, institutions like CEHAD opted to use the archaic legislation to actually hold the ministry to account. So now that we already knew that we were partners that were looking at the act, and not just CEHAD, also the ministry was using it to develop the various standing orders that we are actually having. We ought to have thought twice. We don't know what the next pandemic would be for a country, so we ought to have thought twice as well developing the Public Health Act. So in terms of rights-based approaches, there are missed opportunities within the Act that I think we need to pay attention to, and perhaps as lawyers, we actually may want to push forward for. One of these missed opportunities in the Act is a broader conversation of health. We have this law that anybody would be interested in to say, okay, we now have a legislation on health, but I feel like it did take a rights-based approach in terms of that, of advancing health. So while we speak about health promotion within the law, I feel like community participation is missed an opportunity there. I feel like discussions on criminalizing health are a big thing in the Act, and perhaps we should have thought twice about that. And most importantly, conversations around sexual reproductive health and rights, which we are struggling with, and which again, we struggled with so much in during COVID, were a missed opportunity. I think as a country, we have kind of not very good indicators on, for example, young people's sexual reproductive health and rights, and the Public Health Act should have thought about this if it really had taken a human rights-based approach. So it should have thought about the so many teenage pregnancies that we struggle with as a country, and especially among the young people, and kind of craft ways in which we can actually curb these approaches towards public health approaches on teenage pregnancies, on early marriages, on access to contraception, among others, should have benefited so much from the Public Health Act that we have today. But perhaps the window is still there for us to have these conversations, and maybe it's not all lost in terms of how much do we go as a country to take forward conversations on young people's sexual reproductive health rights. Again, I think, again, that observation on patients' rights as a public health perspective and human rights perspective should have taken a bigger angle. At the moment, we have not a legislation, but I think a charter on patients' rights, which when I read the current Public Health Act, it really did not think about this. And I think if we really need to take forward some of the conversations, I feel like we should have thought about patients' rights more. It should have provided mechanisms through which, for example, information received is not disclosed, which could be a breach of patients' rights, especially in terms of privacy. And privacy is quite important when we really speak about human rights-based approaches. So if we transfer information to people, it means that the duty of protecting patients' information is really not thought about. And then communication of information is not thought about. And then how do I ensure that when I am providing my information, including children, that some bit of anonymity of whose information is provided in terms of patient safety and rights and protection is concerned, was also a missed opportunity in the Act. And then the other thing that we missed as an opportunity is conversations on, again, picking from COVID, quarantine, and providing basic needs for individuals. Again, a human rights-based approach would expect that individuals that are isolated in facilities are catered for by the government. But the bill as we have did not pick so much experience from COVID-19, and we left the power to medical officers and others to kind of come into this. I feel like the government was not taking responsibility in terms of, if we had to have an outbreak the way we had COVID, who takes responsibility where people are quarantined or put, and who ensures that their rights are really protected from that perspective? I think it's a missed opportunity in the legislation. And lastly, I think we missed out on conversations of the role of other actors, including us as lawyers and civil society, into advancing health as a public good. Of course, the human rights-based approach requires participation of everybody, but perhaps when it comes to such a legislation, actors like civil society, like other private actors' role in terms of public health should have been more streamlined today. At the moment, we know that even health as just a right is provided by various entities, including private entities, but perhaps the Public Health Act should have taken a human rights-based approach to think about the role of those private actors in advancing health in this country. I am glad to respond to any questions that may come up, Ms. Nsereko and the team, and I really want to appreciate you for asking me to have a conversation about the right. Thank you.
Thank you so much, Ms. Nachevo Kanoro Musisi, for bringing out the human rights-based aspects. Of course, we cannot talk about enforcement, talk about public health, without talking about rights. Rights come handy. So striking a balance between public health measures or enforcement and human rights becomes critical and very important for us as the legal fraternity. So we are going to go into our next topic. Public-private partnerships in health. I think this was more prominent during COVID-19, where we saw private actors making contributions, huge contributions to the COVID-19 implementation. So there are quite a number of people were making in-kind contributions, some were monetary contributions to ensure that we can be able to avert the effects of COVID-19. And I remember vividly the president was reading lists of people whenever he would make his speech. So we'll have Dr. Ahimbisiwe Expeditus. He's a principal health economist in the Ministry of Health. We'll be taking us through what do we mean by public-private partnerships in health. Dr. Ahimbisiwe, the floor is yours.
Good morning, everybody. Good morning. Are you seeing me?
Yeah, very well, sir.
Can Mr. Muhumuza kindly share my presentation?
Yeah, we are going to project it.
Yeah, can you project my presentation?
Doctor, the presentation is up.
Where is it? I don't see it. Where is it?
Yeah, Doctor, it is shared. Yeah. It is displayed on the screen here.
So where is it? So,
maybe, Doctor, if you have it on maybe a laptop or printed, you can start. We'll keep on sharing the slides here as you present.
Right. Okay. So, good morning, members. This is a presentation about public-private partnerships in health. And definitely, as you have observed and I have said it, the private sector actually plays a very big role in the implementation of healthcare services, especially in Uganda. And you saw this actually during COVID time, when majority of our patients actually went to seek healthcare services in the private sector when the government health facilities were overwhelmed. So my main topic today is there is increasing interest in using public-private partnerships to mobilize funds for and enable reforms in the health systems. Yes, it is true. If you observe currently, we have quite a number of private practitioners and private participants in healthcare service delivery. Definitely, if you look, for example, at Kampala alone, if you look at Kampala city alone, if you count government health facilities, you find they are quite minimal compared to the private sector. And the private sector actually plays a very big role. And here I can see from the main points you want me to talk about is here we would offer a legal professionals guide to the intersection of public health in trade and investment. And another one is COVID fund, legal standing of government of Uganda, act of soliciting funds, legal and institutional framework that govern public-private partnerships in Uganda, and how the concept of public-private partnership fits in the local vaccine and pharmaceutical manufacturing, and what opportunities exist for lawyers in terms of coordinating executive PPPs and do PPPs work in health sector. Maybe let me go straight to my presentation so that we can see if I can answer most of those questions read above. So in health, public-private partnership is actually joint ownership of program proposal by two or more parties to achieve a common goal, and it is a higher level of collaboration. And definitely it is two or more partners who have agreed to work together towards a common goal through the joint utilization of complementary resources and expertise, complementarity, not competition among partners, respect for identity and autonomy of each partner, and each partner may contribute to different extent and with different means to the achievement of the common goal, not the same level of engagement for partners. But of course, here currently the major partners we have in health are Uganda Catholic Medical Bureau, Uganda Protestant Medical Bureau, Uganda Muslim Medical Bureau, and Uganda Orthodox Medical Bureau, and also Uganda Health Federation. Uganda is committed to achieving the universal health coverage through decentralized health service delivery system. And the decentralized health services is intended, among other benefits, to improve delivery of social services with effective private sector participation. And the private sector has a role to deliver quality social services in local government. There are, however, low levels of private sector participation in health sector, especially in local governments. And most of the private sector players are mostly based in urban and peri-urban areas. And you have observed this one. For example, in a country setup, we don't have high caliber hospitals like Case Clinic, like Paragon, like Platinum, like Kampala International Hospitals. Most of these powerful hospitals and the other healthcare service providers are based in the urban areas. In rural areas, we have got what we call traditional herbalists, and these are actually also, most of our patients actually first seek healthcare services with traditional herbalists. But unfortunately, we don't have a legal understanding on that traditional herbalists in the way they are supposed to handle our patients. And I think that is also something you as legal people to look at. The government does not really have much with the traditional herbalists. And I think you have observed that there are quite a number of many of them in town and also in the villages. So government has put in place policies and plans to address health sector development in the medium and long term. The government has prioritized partnership between, you can see, the health development partners. The health development partners here, we mean like WHO, for example, WHO. We have got UNICEF, we have got World Bank, and other international multilateral organizations. But these ones, their agreement, sometimes the international obligations, like WHO, for example, if there is an outbreak of COVID or Ebola, WHO, UNICEF, and other organizations have to come in because it is part of the understanding between the governments and those organizations. So we may not have much legally in Uganda binding us in those areas. Then we have got line ministries and agencies like local government and Ministry of Justice. Then we have got private sector stakeholders and providers like the PNFPs, as I mentioned earlier. Then we have got civil society dealing with healthcare services. Then the general objective of partnership is to establish a clear institutional and legal framework to effectively build and utilize the full potential of the public-private partnership in Uganda national health development, and also to establish a functional integration and support the sustained operation of holistic healthcare delivery system by optimizing the equitable use of available resources and to invest in the comparative advantages of the partners in order to sustain scope, quality, and volume of services to the population. Then the principles of our partnership is joint action at all stages, planning up and intermination, complementary roles, expectation of each other, clarified and stabilized, creation of temporal system, task force with representative from both sides, continuous communication, line of communication between partners to be always kept open. Then at the Ministry of Health level, the policy proposed that the establishment of PPH node for the following purposes. Actually, we no longer have a node, it is now a division. Then we have got advocating and facilitating partnerships at different levels, liaising with private health sector partners, collecting and disseminating relevant information, facilitating operation and research into specific PPH issues, and acting as secretariat for PPH technical working group. Then at the local government, district and cities levels, the policy provided for establishment of structure of PPH desk, and the PPH node at the center has achieved remarkable progress. Most of the local government level PPH desks have been established. And the private sector is playing a big role in responding to emerging health service needs, such as providing vaccination services, managing clients with chronic illnesses, treating those affected by outbreaks, and linking the youth to priority health services. And the need is more amplified by the current rapid expansion of the health private sector, which brings about critical need for collaboration, coordination, and quality control. The private health sector in Uganda is varied and diverse. The following categorization has been agreed upon during discussion with various stakeholders in Uganda in the creation of PPH policy. We have got private not-for-profit providers, we've got private health practitioners, traditional and complementary medicine practitioners, which is, there are quite a number of them, because actually, believe me, 90% of our patients first go to the traditional and complementary medicine practitioners, but the link between us and them is very limited. Then we have got civil societies dealing with healthcare services. Then the role of private sector virtually is providing priority services to the communities with which they operate, contributing towards policies, development, planning, and monitoring and evaluation. Definitely is resource mobilization for healthcare from households, organizations, both local and international, providing, participating in research, community and social mobilization and advocacy, capacity building, including human resource development, logistics support, technical assistance, and other services at all levels, and ensuring proper utilization of resources and accountability. The principal partners at central levels are Ministry of Health, local government, finance and planning, education, public service, and health development partners, designated representatives of the private sector. Then the role of central government, is definitely a policy formulation, standard setting, and quality assurance, strategic planning and research, regulation of healthcare providers, validation and accreditation of regulation and bylaws, resource mobilization, capacity development, provision of nationally coordinated services, e.g. epidemic control, coordination of health services, capacity building through training and supervision, monitoring and evaluation of overall sector performance. Then the role of the Ministry of Health is to advocate and facilitate partnership at different levels, trials with private sector partners to collect and disseminate information, facilitate operation research into specific PPH issues, to act as a secretariat for the PPH working group and sub-working groups. Then umbrella organization is to present their members and to promote partnership initiatives, to coordinate the different health providers from each subsector, and provide support services and accredit the member facilities and providers. Then we have got coordination committees to represent the subsectors, facilities, providers, and programs at different ownership existing at district level, coordinate facilities, providers, and programs from each sub-sector, to mobilize and connect resources, flow between district and private sector, and to harmonize approaches, define the common issues, propose solutions, and ensure information exchange. Then we have got facility-based. Now, facility-based, these are, as I told you, Sambya, Lubaga, Mengo, and other hospitals, for example, which we call private not-for-profit. And of course, also we've got also private for-profit like Nakasero, Case Clinic, Paragon, etc. Then these ones are facility-based PNFP providers, have a large infrastructure base comprising a network of hospitals. They currently operate around 30% of their care facilities. And many of these PNFP's facilities provide health services as well as trained health workers. And about 75% of the PNFP facilities are represented by 4 medical bureaus, as I've stated earlier. Then we've got non-facility-based PNFPs. These are civil societies, which may not directly operate through health facilities, but which support and undertake health development activities in partnership with central and local government, with facility-based and other PNFP health facility providers, with private practitioners, with communities. Diversity within this category of providers exists by a large combination of characteristics, include size, means of, and access to finance and control and motivation. Then we have got private health practitioners. The private for-profit health sector encompasses all cadres of health professionals in the clinical, dental, diagnostics. Diagnostics, we have seen now MBN laboratories. We have got in Simba Manual, we have got medical radiological machines, and they do a lot of work in investigations. We have got midwifery, we have got nursing, pharmacy, and public health categories who provide private health services outside the PNFP establishment. And you have got the private health practitioners have a large urban and peri-urban presence and provide a wide range of services, mainly in primary and secondary care. Then few PHPs provide tertiary level services, but of course, currently we have quite a number providing tertiary healthcare services. You have seen Nakasero Hospital is doing a great job. Case Clinic is doing a great job. Curative services are widely offered, while preventive services are more limited, with the exception of family planning offered by 3/4 of PHP facilities. Then, as I said, traditional complementary medicines facilities shall be, they need to be accredited and operate by respective competent umbrella organizations. But this area definitely still has issues. The facility shall operate within the mission and policies set by umbrella organization. The facility shall be licensed to operate by Uganda medical and dental practitioners, which they are not doing. The facility shall maintain premises adequate to the expected service. The facility shall be staffed with qualified personnel, and the traditional complementary medicine practitioners shall be registered with their respective regulatory bodies. But unfortunately, most of these people are not registered, and you have observed that there are quite a number of them operating, I would say, illegally. Like you have heard about bone setters, you have heard about traditional birth attendants, you have heard about those people who normally say that they heal all types of diseases with using certain herbs. So indeed, they are not well really regulated in the healthcare system. So a significant proportion of population often seek the services of traditional medical practitioners, and traditional medicine practitioners include all types of traditional healers, including the herbalists, which I've said, traditional bone setters, you have heard about them, traditional birth attendants, hydrotherapists, and traditional dentists. I think you have seen them, those who normally use crooked tools to doing their work. The sector does not recognize or embrace people who engage in harmful practices such as casting of spells and child sacrifices. There are several associations with registered members of the sub-county and district level coordinated district community officers. And complementary medicine is provisionally defined as art of using natural, physical, and psychic means or products to cure or modify diseases. And that is the end of presentation, but I needed Yes, I needed to at the main points. The COVID fund, legal standing government of Uganda soliciting funds. This is at multilateral level, like WHO, UNICEF. These are organizations which already have an understanding between government and themselves. Then legal institutional framework that governs public health, it is there, but they're not very strong. How the concept of public-private partnership fits in local vaccine and pharmaceutical manufacturing. This one is not yet very strong, though available, but it's not yet very strong. And what opportunities exist for lawyers in terms of connecting with PPPs? Unfortunately, in health, we don't have strong PPPs which our senior lawyers can benefit by now, because our PPPs are still very low in the health sector, and most of them are unsolicited. They're not solicited, they are unsolicited, but they are not yet very strong. The PPPs work in the health sector, yes, they do, but not very strong linked. I think that's what I had for now. Thank you.
Thank you so much, Dr. Himbisugo, for enlightening us about public-private partnerships in health. You have opened our thoughts on what this means for the health sector. We have one comment or question here from Mr. Robert Beikaize. One here, thank you for the good presentation. And he has a question. As a ministry and government, what strategies and plans do you have in mind to finance public hospitals, especially those up country, and also improving the remuneration of intern doctors currently on strike? I don't know if this is PPPs, but you can possibly answer.
Of course, that one I can answer it quickly. Of course, as government, I would refer him to our ministerial policy statement. Definitely, government hospitals are funded, but of course, as you know, government is also limited. It has so many competing priorities, but definitely government hospitals, I will not say that they are fully funded, but at least we try to fund them, and somehow they are fully functional. Then for interns, definitely interns, of course, for example, interns actually, we have issues with the interns. For example, we have so many universities now producing interns. You find KIU with 400, Guru with 500, 200, Makerere with 200. So right now, government is trying to see how to plan for these interns, but definitely they will be supported to do the internship when the funds get available. I think they will be in they are trying to look for the money to ensure that these interns are financed so that they can start the internship. But definitely, you see, formerly we used to have only one university, Makerere University, producing like 100 doctors. So you would know that this year we have 100 doctors. But right now with the private universities, they come like now I was told that now we have 1,900 interns. So you see the problem, the planning part of it becomes a problem, but we shall start now moving to universities, maybe when they're in 5th year, get their numbers and see how many are going to come out so that we can plan for them well. Thank you.
Thank you so much, Doctor. I think we need to explore PPPs when it comes to interns and see how we can have public-private partnerships when it comes to internships based on those increasing numbers that Doctor has shared. So, Doctor, I'll come back to you in case we have any other question or comment from your end. We are directed now into the plenary session. Already some questions are coming in. I already shared a question raised by Robert when he was asking about compulsory vaccination for children, and what if parents can be, if their consent has to be sought. Martha is back on the call. She can respond to that question before we have the rest of the questions. Martha, kindly.
Is that vaccination mine?
No, it is for Martha.
Okay,
Isabella,
fine.
Council Martha, yeah.
But as she comes in, Definitely, vaccination cannot be compulsory for children before the mothers, the parents actually consent. So that is a long thing. The parents must consent as a matter of fact. As a Martha comes in, yes.
Yeah, Martha, are you online? Yeah, as she comes in, I had already shared the question with her, and yeah, Martha is back. Yeah.
Yes, I'm back. Thank you very much. And I'm sorry, I'm carrying out two sensitization at the same time. As I'm carrying out sensitization in the society, we also sensitize in the media. In the same law. And interestingly, the question I've been asked is also very hot here. The same question is being asked here about child vaccination.
Martha, it seems we are not getting you well. Yeah.
Because your body should be fit, fight.
Okay,
So if it's
now let me move to a quiet place.
then
Can you hear me now?
so they first ask questions. How is the child?
Can you hear me now, please?
Any issues, when you say yes, what kind of issues? If they realize that compromise their own.
Martha is getting a good connection so that she can be able to.
Is this better? Is it better
Yes,
now?
it is. It is.
I had to turn off the video to make it clearer. So interestingly, I'm carrying out a sensitization to the media on this same law. And the question I'm being asked, the same person I was actually answering here about childhood vaccination. Okay, so to answer the question, a parent cannot be forced to present their child for vaccination. However, for this particular law, children vaccination is mandatory as opposed to adult vaccination. So you may have to read section 38 very clearly. It talks about mandatory vaccination for children. And also section 45 provides that no child can be admitted to school, be it a daycare, primary school, without presenting the vaccination card. And I want to explain, dear colleagues, that much as this is an issue right now and a question, at the moment in Kampala, we are seeing very many cases of mumps. And about a month ago, I was requested by a colleague, the KCCA, to give an advice about section 47, which says there's no mandatory vaccination. The minister can only request residents to actually receive the vaccine. This particular provision has caused already a problem in the response, because now with many schools were turning away officials from KCC who are trying to carry out vaccination for MMR, that is measles, mumps and rubella. And now we have very many cases of mumps at the moment in children. But however, to answer the question very clearly, children vaccination is mandatory, but a parent cannot be forced to present their child for vaccination. However, if you don't vaccinate your child, you will not be able to access school. That's what in section 45. I hope that is clear. I thank you.
Yeah, I think it's very clear. What I'm picking is that we need to read the law. I know we have just had an overview and the conversation, but I think as legal practitioners, this is a very important legislation for us to read, given that the conversations that we have had point to quite a number of issues that relate to public health, which are not necessarily health, but issues of tax, issues of procurements, issues of schooling, the presentation of immunization cards before you enroll in school. So there are quite a number of emerging things. We thank you, Martha, for that response. And I think in case people have further questions, we'll be coming back to you to raise them. We have another question from Noah. No. There's a question from Noah about Nura Mwanga was asking whether human rights have been clearly articulated in the Amendment Act and not the right to health. So I think she's asking whether human rights have been beyond the right health or beyond access to services She's asking if other human rights have been articulated in the Amendment Act. Maybe Noor, you can come in to share, and maybe Martha, if you have any insights, you can also possibly come in after Noor.
I think thank you, Mr. Serukan. Thank you for the question. The Public Health Amendments Act has defined public health, has not defined health, but I think the Constitution is very clear on other rights. So really, this was really focusing on public health, and others are left in the Constitution. So I don't see many of these other rights in there, in the Public Health Amendments Act, apart from health in its entirety. Not so much in its entirety, but I think there's a lot of clarification on health and not other rights, which I think should not be a problem, because I think Chapter 4 of the Constitution clearly indicates other rights, but also other legislations on specific rights, like the Education Act and the Right to Education, are very clear on that. Thank you.
Martha, do you have any take on that?
Yes, it's a very interesting question. We don't usually repeat provisions from the Constitution. We did it, I think, once to clarify on service delivery. So as the earlier speaker said, Chapter 4 is still binding on us, even for the Public Health Act. However, during epidemics, and I think it's also in the Constitution, some of these rights will be waived. The right to movement, that's why you saw us passing these laws, lockdown, those community quarantines. In the face of an epidemic or a pandemic or a serious outbreak, those rights will be waived. You have schools closed, places of worship closed, restricted movement, and that also is catered for in the Constitution. It's an exception. That is why when it was necessary, we had to pass laws, because we could not just tell people, don't go to school, don't go to work. It had to be by a law, not just by a verbal declaration by the president. So I hope that answers your question. Thank you very much.
Thank you. The floor is open for questions. I don't know if there is anyone who has any other comment or question from the listeners. Do you have any more questions or comments? You can raise your arm and you can raise your question, or you can share in the chat. Yeah, you can share in the chat your question. So we have someone that is based in the community. They are community health advocates, and they have interfaced with the enforcement of the public health measures. So we are going to have Jesse paint for us a picture on how public health measures have been enforced briefly before we go into the next question. Yeah.
Thank you so much, our moderator for the day, Mr. Nsereko. Well, my name is John Jesse Navondesi, a community health advocate from Wakiso District, and also a youth advisor on behalf of the SRHR Alliance, representing SEHAD. So I won't talk much because the experts have said most of it. However, I would just like to translate some of these legal terms into some of the things that we have been experiencing in our day-to-day lives in the community. I'll only mention two things. Number one, I want to talk about access to sexual and reproductive health and rights information and services. Well, we are aware that the Act mandates the provision of public health services, including sexual and reproductive health and rights services by the government and other relevant stakeholders. However, in communities, we have places where they can't even access digital devices. And if we go back to the COVID period, we remember how the issue of access to health services and information was we were trying to shift into a mode of digitalization, but then how were we thinking about some of these communities that can't access digital devices? And also the limited availability of services. We have places, I won't go far. I'll give an example of a place like Kasokoso, which is here in the center, close to Kampala city. But then this place doesn't have a health facility. Kasokoso is a slum that has over 1 million people. It's actually just a village that has over 1 million people, but without a health facility. People during the COVID-19 pandemic were footing from this place, going to access services in either Boyogere, going to access services in Mutungo. But then how are we thinking about such places that people can't even access the services they need, including sexual and reproductive health services? Number two, I'll talk about the age of consent. Well, Dr. Mulumba talked about the issue of consent earlier, but then the act requires someone to actually be the age of 18 years in order to consent to medical treatment, including sexual and reproductive health and rights services. However, in the communities we live in, we really know what is going on. We know that young people are engaging in sexual activities even before the age of 18. How will this young person be able to acquire consent from their parents or guardians in order to go and access sexual and reproductive health and rights services? I don't know how we are thinking about some of these realities that are ongoing in regards to young people's sexual and reproductive health services and information, and also people in the community, because this is actually implying to the whole of our societies, the societies we come from, the communities we live in. So I think we need to respond to that. Thank you.
Thank you so much, Jesse, for that. I don't know if we have any more questions or comments for those that are attending virtually. We are coming towards the end of the CLE. I don't know if we have any questions or comments. I don't see any in the Q&A and even in the chat. I don't see questions. It seems people have enjoyed the presentations, but this is a start of the conversations. As we ask questions, we encourage all of us that have attended to join the Health and Law cluster. We have quite a number of interesting initiatives and conversations beyond the CLE. So we encourage and urge everyone who has attended, and also those that are out there who have not attended, to be part of the cluster, such that they can to benefit and get acquainted with what health and law means, and also have identified opportunities for their practice. So without taking a lot of time, allow me to invite Miss Dorothy Amron, who is a member of Uganda Law Society. She coordinates the SGBV cluster of Uganda Law Society. She's also a manager of strategic litigation at Center for Health, Human Rights and Development, to give us closing remarks. Dorothy, the floor is yours.
Okay, thank you so much, Mr. Ibrahim Nsereko, for ably moderating this very powerful session, and specifically to Uganda Law Society for always giving us a platform to update ourselves in terms of the emerging topical issues when it comes to health. This area is very interesting because it touches the very bottom of every single person in the communities. So allow me to thank so much our facilitators, the keynote speaker, the facilitators therein. We've heard from Martha, we've heard from Ministry of Health, we've heard from private practitioners, community voices in terms of what their take is when it comes to public health. And for me, I think the takeaway in applauding our presenters in giving us a lens of the different aspects of public health has meant that public health law, really primarily the objective is to definitely pursue the biggest possible level of physical and mental health in the population. And we are looking at consistency with the values of social justice. So we will not be concentrating mainly and reviewing our laws when it comes to pandemics, epidemics, endemics, but we should look at public health comprehensively to be able to benefit and serve our public better. So we applaud the ministry and the government, of course, for taking strides to review a very archaic law that was enacted in 1935 to be able to reflect the emerging public health needs of our society. I think for me, the plea would definitely be for us to, as a government, to always look at the issues that are emerging and that are pertinent to the society in totality beyond the pandemics. And I'm so happy that, of course, there were rules that were developed to handle the COVID pandemic. We also have the national health policy that is in place to guide, but I'm also hoping that where there have been missed opportunities in addressing the gaps within our society, that the regulations will be alive to these gaps that have been highlighted by the different facilitators. We had our colleague, Ms. Noor, talk about the health rights issues. You cannot talk about public health and not talk about health rights considerations or principles. And I think for me, the takeaway is the spirit of public health should look at the importance of self-care as a value addition. The country has national policies, but when you're talking about public health, we cannot ignore certain aspects in terms of accessibility and infrastructure, human resource, and all those other things that make health a lived reality. Not to say the national insurance health scheme, because we're trying to talk about accessibility, affordability, adaptability, acceptability. All these principles should be very critical and play a critical role when we're revising some of these laws in our country. They should not be alien laws. They should not be difficult to understand and interpret, but they should serve our public. So I thank you all for participating actively, those that sent in their questions, the community voices within this room, the lawyers that have taken a keen interest on health law. It's the backbone of development, to be honest. And as we discuss all this, I hope that we're looking at it from a healthy nation is a resourceful nation, and therefore we should make health a lived reality for our population. Sexual reproductive health rights issues continue to come up day and night. And I think that while we were looking at the spirit of amending the public health, it was mainly informed by the pandemic, the Ebola outbreaks. But I think there are also other contributors to health when it comes to issues around social well-being and the World Health definition of what health entails. So let's look at public health comprehensively and use these opportunities to better our laws and let them have the spirit of progressiveness. I thank you all, the participants online. You've been amazing. Please join the health and the law cluster, like Mr. Ibrahim Nsereko has said. And with those remarks, I wish you all a very good afternoon and rest of the week. Happy Eid to the Muslims. We're not yet sure about when it is. We were hoping it's a Friday tomorrow, but let's wait and see from the voices that be. Thank you.
Thank you so much, Dorothy, for those wonderful closing remarks. I can't add anything. We look forward to our next conversation on health and the law. And until then, I wish you a blessed day. Thank you.